want to discuss the actual transaction scheme itself and give a clear picture as to when the transaction scheme became relevant. Okay, so in terms of the securitization, it's a special deposit IRC 1031 exchange. At first, I want to give light to the Glass-Steagall Act, also known as the Banking Act of 1933. Okay, and this was enacted related to regulation and the failure of banks during the Great Depression, the regulation of offering securities on the secondary market. Okay, so essentially here, Bill Clinton in 1999 signed legislation reversing and deregulating consumer credit lending practices, diverting risk to the secondary market, making way for an IRC 1031 exchanges on prime market real property and after acquired collateral or electronic chattel paper under revised Article 9. This is key, okay? The paradigm shift from where's my note, where's my loan, and standing related to negotiation of the obligation, the tangible obligation, where essentially in terms of what we've seen, a majority of folks are failing on standing to defend the collateral and presenting to the courts an issue of equity of how you've been harmed based on the contract, okay? So I want to give a clear picture as to what the REMIC's making a claim to related to the lien encumbering your real property. A big thing that's popped up, the reason why I wanted to take us to Glass-Steagall first is to understand this part here. This regulation prohibited commercial banks from engaging in investment business, okay? And that's what we're going to focus on now, this 1031 exchange, banks engaging in investment business. Okay, and I've gotten some pushback from experts, from industry professionals that just do they're familiar with real estate transaction and an IRC-like kind of exchange as it relates to capital gains deferments on ownership of real property. And I wanted to give a clear picture as to the lifting of regulation and what made way for this. And this is directly from Wikipedia as the source. I'll let you guys show that, but I'm going to give you the gleaned information that I want you guys to understand. So to qualify for Section 1031 of the Internal Revenue Code, properties exchanged must be held for productive use in a trade or business or an investment, stock, bonds, or other properties as listed as expressly excluded by Section 1031 exchange of the Internal Revenue Code, though securitized properties are not excluded. Okay, and that's directly from MERS's language as well. MERS is the vehicle that executes and controls the electronic chattel paper, but we'll get to that. The properties, so that's the main thing that I wanted to discuss here. I've got a lot of pushback on 1031 exchanges and the tax deferment and the structure under the IRS code isn't applicable to the securitization transaction, and that couldn't be further from the truth. Okay, we're going to go through the chart here in a few minutes. But what I wanted to do, so first things first, on the syllabus we have covering the special purpose vehicle U.S. patents. Let me bring that up real quick. Okay. So this is from the U.S. Patents Office, special purpose entity for holders of financial instruments. Here's the patent number. I'll make this available for your review. Okay. Wanted to go to summary of invention. And the reason why I wanted to cover the summary of invention is to understand the order of operations in this transaction. That way we can get a clear picture as to the statutory capacity of all the interested parties. Okay, so first things first, we deal with a lot of issues of whether or not the homeowner is an account debtor, whether or not they've negotiated a promissory note and received consideration in the form of monies for a loan for their home, right? So essentially being an entitlement holder and negotiating their promise, the banking institution accepting the note by consideration, holding it in deposit as a debtor on the instrument. Hold on one second, sorry. So first things first, that didn't take place. There is we're going to go through negotiation and account debtor status in a second on the difference between negotiation and a like-kind exchange. But here, the language from the summation, there's a lot of people calling in, I apologize. So here's the summary, and I broke it down in the language that I wanted to take a look at specifically. So this is directly from the patent document itself, just so you guys can understand. This section is 0006, but here's what we're going to break down. So, summary of the invention. The present invention provides systems and methods for carrying out financial transactions which secure assets and ensure checks and other financial obligations are honored. Okay, let's look at that. Which secure assets and ensure checks, instruments, and other financial obligations are honored. That's very specific language, by the way, as well as provides various other advantages, for example, exemplary. Okay. Invention. A system for carrying out a financial transaction comprises of a financial institution which issues a payment obligation. So this is the accommodation part. We're going to go to statutory capacity. So in the like-kind exchange, the originator inventory lender is this party, the financial institution which is issuing a tangible instrument as a payment obligation, and the special purpose entity is acquiring the residual obligation or after acquired proceeds, which is the electronic chattel paper, the underlying collateral to the tangible promissory note. Okay, so I'm going to go back through that again real quick. Most important thing I want you guys to understand is in the like-kind exchange, what's being bifurcated. In the like-kind exchange, what's being bifurcated is the residual obligation, the electronic chattel paper, the underlying collateral of the tangible instrument itself. Okay, so essentially the receivables are being bifurcated under UCC 8 and negotiated to the remit in the exchange. Okay. So again, order of operation, what I wanted to cover here, this last part, in accordance with various aspects of the present invention, the special purpose entity is provided with the ability to invest the acquired funds prior to honoring the payment obligation to the certificate holders. Okay, so let's just, what does that mean for a second? So under the 1933 Securities and Exchange Act, right, essentially, if you want to induce capital markets or institutional investors, you have to submit a prospectus supplement and governing documents such as a pooling and servicing agreement. Okay, so the investors have the opportunity and their attorneys have the opportunity to review the prospectus supplement, understand the risk of appetite, understand what their acquisition on the securities will yield on a rate of return. So on the securities, all of the yield spreads and risk management, the appetite for risk, are already illustrated in the prospectus supplement relating to the underwriting standards of creating the obligation and the underlying premise of the mortgages being, or the obligations being secured to a mortgage on real property. Okay, so the most important thing to understand about that is special deposit. Okay, special deposit in order of operations is how the money is generated. So they prefabricated the securities, sold the securities, and took the funds in special deposit. That's what the REMIC, the special purpose vehicle, is. The methodology of that transaction is related to accepting by special deposit the certificate holder's funds, right, for an after special purpose vehicle, provided the ability to invest the acquired funds prior to honoring the payment obligation. So they're taking that special deposited funds and utilizing them a line of credit to table fund a securitized loan. Okay, so that's important. That's very different than a homeowner making a promissory note, negotiating their note to a bank who accepts it by deposit, gives consideration, not ultraviars in the form of real money, as a loan. In that case, if that took place, if the financial institution was a Federal Reserve Depository Institution, and all you gurus out there in presentment understand what we're talking about, there has to be a contract to execute account debtor status. So the homeowner would have to negotiate the instrument, the banking institution would have to deposit the instrument and give consideration in the form of a loan to create a contract of account debtor status. Okay. Biggest thing that I want you guys to understand is that never happened. that fact never happened, or that purported fact never happened as it relates to your capacity to the note. The methodology of the special purpose vehicle is to execute financial transactions, securing assets to real property collateral, which is construed as after acquired proceeds of the real property, and ensure that the UCC-3 instrument and other financial obligations are honored. So the methodology of the special purpose vehicle is to generate funds through the sale of the certificate to the certificate holders in special deposit to create the funds for a credit swap or like-kind exchange, which we're going to cover here on the chart for a second. Okay. Purpose of the transaction, to create residential mortgage-backed securities. So that's just what I described as the underlying meaning of creating residential mortgage-backed securities. Most importantly here, I wanted to explain to you what your capacity of the parties to the original contract look like in terms of statutory capacity. So you have the homeowner, and you also have the non-payor originating bank acting as an accommodated party. So in the exchange, here is the specific statutory capacities to the two interested parties at the closing table. The lending institution is acting in the capacity of an accommodated party, a financial institution who issues a payment obligation, tangible UCC-3 note, as an account debtor under 3-419 as a representative other than a depository bank who has in good faith dealt with an instrument or its proceeds on behalf of the special purpose vehicle, one who is not the person entitled to enforce. That's key. Okay, the special purpose vehicle is not the proper party to enforce the tangible promissory note in the like-kind exchange. Okay, so just wanted to make sure you understand that. Instrument is not liable in conversion for the after acquired proceeds of electronic chattel paper to the person beyond the amount of any proceeds that's paid out. So I'll cover that in deeper understanding later on. But again, the originating party for this instance is the accommodated party under 3-419. Okay, the homeowner is acting as the surety or guarantor who has pledged their real property through cost acceptance to be a participant in the accommodation transaction. So let me slow down there for a second. Whether or not there was an actual contract and you negotiated your note with the bank and they gave you consideration, right? Or this was a IRC-like kind of exchange, the homeowner's intent of the contract was the same, to receive an obligation so they could get the real property, to get a home, the collateral itself. Okay, so the reason why I want to take a moment and slow down here is it's very important, and one of the biggest things that I ask folks all the time is, do they understand their capacity into the transaction in IRC-like kind of exchange? Well, I'm going to make sure that you understand that here. You are acting as a guarantor, a surety under 3-419. Okay, you're the accommodation party, and what you've done is you've cross-accepted the real property by they recorded the grant deed or warranty deed on your behalf without your knowledge, so that you could pledge back the deed of trust lien or mortgage lien to encumber the collateral in the transaction scheme. Okay, so as the accommodation party, you're the grantor of the real property collateral, and you've executed the instrument as a guarantor to the non-payor bank or the mortgage loan originator. Okay, so going through here, special deposit IRC-like kind of exchange chart. Now, I've said a lot of things here that can be challenging to take a look at in terms of understanding the specific language. So let's take a chart and give light to that. Okay. So step one, we've discussed what is the methodology or the purpose of the transaction. Okay. So step one is to create cash flow by the sale of the ABS securities. Okay. So here's step one. We'll just follow the basic order of operations. Cash flow, purchase of ABS securities. That's where it starts. That's your special deposit on the sale of the securities, right? So let's say the mortgage loan originator has dealt with you on, let's say, for a refinance transaction, and you've submitted to the originator your underwriting material related to income verification, tax returns, so they can verify your creditworthiness related to what the underwriting standards are on the securities through the prospectus supplement look like related to the yield spread on the securities that were sold. So as long as your underwriting capacity as a guarantor or a homeowner in this transaction fits the underwriting requirements of the securities, then you can process a consumer credit transaction for a refinance or a purchase. So what they're looking for is, at the time of origination, is does your creditworthiness and your underwriting capacity or your ability to repay, does it fit the structure of the prefabricated securities on the secondary market? Okay, if that's the case, then the originator can execute the exchange. This is what's called a warehouse line of credit. Okay, so in step 2, in this process, let's say, for instance, the homeowner has actually executed a mortgage loan package and submitted it to underwriting. Okay, that's essentially their underwriting process, is to ensure that your creditworthy matches up with the yield spread on the payment of securities. Okay. At that point, if you do qualify for the loan, then, and they're positioning you to close on the loan, then we have what here in the 1031 exchange, we have 2 parties related to the what the 1031 exchange is, that the investment vehicle is bankruptcy remote, so 2 bona fide transactions out and back from the original closing table. Okay, and here's what that looks like.
Hey everyone! Are you looking to sue your bank for mortgage fraud or foreclosure fraud? If so, you should call Fraud Stoppers right now, because we'll show you a proven way to help you save time and money and increase your odds of success, getting the legal remedy that you deserve. Remember, when the banks break the law, we break the banks. So call us today. Until then, see ya!
So again, here's the source for this material. So a big thing I wanted to describe to you guys is, in the pooling and servicing agreement, many times what you'll see is you'll have the originator, the sponsor seller, you'll have the depositor, and then the REMIC. And those, so you have, in this instance, let's say, for instance, the REMIC, you'll have the depositor, you'll have the sponsor bank, and then the originator. So that's how I want you guys to look at that. But what the big thing is that I want you guys to wrap those 4 parties in terms of indispensable parties into the pooling and servicing agreement, so you can see that from A to Z, all of these parties are working in concert. They may be separate and distinct entities, but through the pooling and servicing agreement, it is a constructive transaction from A to Z. Okay. One of the big things that I wanted to give reference to is the Starker versus United States case, and I can provide all of that information for you guys as you move forward, but it's relevant here for this particular understanding of acquiring an interest in the underlying collateral of the real property related to the tangible contracts executed at origination. So here's what the exchange looks like. Here's the information that I wanted to go over with you guys here. For a non-simultaneous exchange, the taxpayer must be a qualified intermediary, follow the guidelines of the Internal Revenue Service. So that's language, again, I wanted to make sure that you understand, from the entity structuring and transferring the tax liability to the certificate holders on all those transactions. This is the framework of the exchange in terms of their tax liability and entity structuring. So we'll definitely bring you to that information as well. So these 2 parties are qualified intermediaries. If you really dive down into the pooling and servicing agreement in terms of what's taking place, it definitely is an exchange of credit to create that warehouse line of credit to simultaneously fund that loan at origination, or purported loan at origination. So at the time of origination, what are we looking at in terms of understanding what they're attempting to accomplish in the exchange? So when you're signing the promissory note and securing it by the deed of trust, what you're doing is also pledging a deed of trust lien to secure that obligation. So what the inventory lender is doing, and they're identifying typically MERS as their electronic agent, is recording that deed of trust immediately after origination. So they record the deed of trust. You've executed the tangible note, which allows them now to do the exchange. Okay, which is essentially MERS hypothecating the electronic chattel paper, which is the underlying converted value of the tangible instrument. Okay, so we're going to get to statutory conversion in a second, but essentially here, the deed of trust lien is being recorded and perfecting the beneficial interest in the lien to secure that obligation, which is makes perfect sense in an accommodation transaction, and there's nothing illegal with that at all. Everything is pretty straightforward. Okay, real quick, let's go to the act of recording the deed of trust lien. Okay, so I want to go to perfection. What's the process and procedure of creating beneficial interest? What's the physical act of recording the deed of trust lien in public record? The act of recording perfects the intangible statutory interest. So what we're looking at here is 9315, secured parties' rights on disposition of collateral and proceeds. So let's take a second and let's talk about here real quick the real property itself, which is being pledged and encumbered by the deed of trust lien by the real property owner who's cross-accepted ownership, right? You cannot pledge the real property itself as collateral unless you own it. Okay, so just basic common sense, you accept ownership so that in the same transaction you can pledge back, in the instance of a deed of trust lien, a legal title to the trustee on behalf of the beneficiary of the lien, which is either the original purported non-payor bank lender and MERS, their electronic agent. So when they're recording this instrument, they're creating that beneficial interest, and that's identified in your deed of trust lien. And if you have any questions in that, we'll go through perfection on the lien and the creation of beneficial interest. Okay. So here I want to give language to what is the proceeds versus collateral. So again, the collateral is the real property itself. And under revised Article 9 here, at the time of origination, what they're construing is, I want to read this to you real quick. As discussed in last issue's column, revised Article 9 greatly expands the definition of proceeds so that a security interest in specific collateral will automatically extend to after acquired property that is derived from the original collateral. Again, so the real property is the original collateral, and the after acquired property that is derived from the original collateral is the electronic chattel paper. Okay, even if there is no disposition of the original collateral. Well, this is where I want to right here. I hear people all the time say, well, the note and deed were separated. The note and deed were separated. Well, if there's a contract and a deposit account holding that instrument, and the instrument was negotiated in bearer form under 3205B, they can negotiate the tangible instrument in physical form and not have to perfect a chain of title, right? Because they have a temporary perfection as under the original holder, the original deposit account. And so that never took place. That's what we have to prove, okay? That the 3205B argument is specifically contingent upon the homeowner executing a contract with the bank where they negotiated their promise, their instrument, the bank itself accepted the instrument by deposit and gave consideration. That would have to take place. The instrument would have to be held in deposit. It's well within their right to sell that instrument to a successor, but that would require a very specific procedural process on release and reconveyance of the lien to maintain clear and marketable title. So we'll come back to what the banks are purporting took place. But the big thing that I want to describe to you here is, first things first, that what's getting bifurcated first is the electronic chattel paper from the tangible promissory note. And what's happening is MERS, and there, as an electronic agent, is hypothecating a secured interest of the lien to secure that electronic chattel paper that's been negotiated to the REMIC trust in the exchange. Okay, so this revised Article 9 is what the REMIC is making an obscure claim to the beneficial interest in the originally recorded lien. Again, I want to make sure you guys understand that this is not a where's my note, where's my loan. It was never your note and it was never your loan. Okay, you're just an accommodated party into a like-kind exchange. And right now, what your real question should be is, does the REMIC have an equitable claim to the originally recorded lien based on being negotiated the underlying receivables to the tangible note, and those being in default? Okay, and I'll explain that a little bit more in depth as we move forward. We've talked about the special purpose vehicle patent, and we've talked about understanding what's actually taking place in a special deposit. So now we know that the original lender didn't actually lend money, that they're in a trustee capacity in the exchange to the special purpose vehicle, which I'm going to get to the OCC asset manual in a second. Okay, we've covered all of that relating to what's transpiring there. I want to now go through and cover the MERS patent real quick. So let's do that. So in the MERS patent, what I wanted to do is make sure that you understood what is MERS function. What is MERS function in this transaction? Well, MERS is the software system that the banks have deployed as an electronic agent under the original secured instrument to hypothecate that secured interest to attach to the electronic chattel paper that's negotiated in the exchange. Okay, so this is the system and method of creating, vaulting, transferring, controlling transferable electronic records with unique ownership. And that's directly from MERS patent. I don't know how to be any clearer as to what its function is. Without question, I'm going to say that again. The system and method for creating, vaulting, transferring, controlling transferable electronic records with unique ownership. Okay, so we've covered what's actually taking place in terms of bifurcating the electronic chattel paper from the tangible instrument. MERS, as the electronic agent under the deed of trust, is hypothecating a secured interest of to secure the payment intangible under this obscure claim under revised Article 9. Okay, so that's unequivocal. In terms of judicial notice, that's the methodology and the function of the MERS vehicle software itself. Okay, page 63. I wanted to cover the MERS conditions. Get the right language here. MERS and its members agree that MERS system is not a vehicle for creating or transferring beneficial interests in mortgage loans. Okay, and we'll come back to that under Article 9 to prove that statutorily beyond any reasonable doubt. But that's from their own language. Although MERS tracks changes in ownership of the beneficial rights, beneficial interest and beneficial rights are two different things. For loans registered in the MERS systems, MERS cannot transfer the beneficial rights to the debt. The debt, the tangible instrument, this is the part we're talking about bifurcating the electronic chattel paper in the exchange. Okay, so stay razor sharp here. I know I'm going quickly, but again, this is from the MERS language. MERS cannot transfer the beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to the transferee in an ordinary course of business. Okay, so we're going to get to ordinary course of business 3308, 7501, 3201 very, very soon. But essentially, you can only, by their own admission here, the debt can only be transferred by properly endorsing and essentially disposition, selling the note in an ordinary course of business for full value to transfer rights of enforcement over the debt, the payment obligation. Okay, so it's making very specific language that MERS cannot negotiate the debt, right? They can only control the underlying electronic chattel paper that's been bifurcated under UCC 8 in the exchange, the personal property. So essentially what's being done is the originating party is bifurcating their right as an accommodation party to your payments in the exchange on behalf of the REMIC. So the only thing that's bifurcated at this point is the electronic chattel paper from the tangible note. I wanted to make sure you understand that. Where are we at? I'm going to cover I'm going to make sure you guys, and definitely get with me, I'm going to make sure you guys have all the supporting content, but I wanted to go back and just, again, from an entity structuring standpoint, give reference to the Tax Reform Act of 1984 and the creation of entity structuring, so to transfer the tax liability to the certificate holders. And I probably should have started there in relation to the chart so that you could understand the requirements of the investment vehicle being bankruptcy remote, okay, meaning two bona fide transactions on the obligation before the REMIC takes possession of the trust asset so that they can defer the tax liability through all those it could be a tax pass-through for the certificate holders. One second, guys. Sorry about that. So again, here in REITs, the creation and the specific language of a REIT, a real estate investment conduit, as it relates to the tax liabilities and the deferment of the tax liability to certificate holders. So I'm going to send you the Tax Reform Act so you have that information as well. On the OCC Asset Securitization and Comptroller Handbook, capacity of indispensable parties into the transaction. Well, we've covered right the accommodation party, right, the borrower here. So this is parties involved with structuring asset-backed securities, Exhibit 1. This is directly from the OCC's office in terms of, let me enlarge this here. This is going to be key in terms of making sure that you can wrap everybody in a constructive fraud related to the like-kind exchange through the pooling and servicing agreement. So this is directly from the Comptroller's Handbook of 1997, asset securitization. The big thing I wanted to show you guys this is that as an accommodation party, the originator is most definitely a party to the securitization. They're an indispensable party to the securitization as a guarantor on the payment obligation, and then subsequently the pledger of the real property collateral in the exchange. Okay, so again, here is unequivocal clarification that the homeowner and everybody are in concert in the like-kind exchange. Parties involved in structuring the asset-backed securities. So you have you have the accommodation party, you have the accommodated originator, who's the account debtor on the tangible instrument. They record the deed of trust under 9315A to execute and create beneficial interest over the real property collateral evidenced by the deed of trust lien as a secured party of record. Then the tangible note is converted. We're going to go through conversion, statutory conversion, into electronic chattel paper. The MERS vehicle controls the electronic chattel paper through the exchange and is purportedly hypothecating a secured interest over the electronic chattel paper to secure the transfer to the REMIC, the asset to the REMIC, prior to the cutoff date of the REMIC trust in accordance with the pooling and servicing agreement. Okay, so in terms of standing, okay, all the issues in demurrers or in your affirmative defenses where you're dealing with challenge of standing, this is important in terms of understanding exactly what material evidence you need to prove to show that. Okay, that's why I wanted to make sure you saw this. So through the pooling and servicing agreement, through this instrument, everybody is associated in terms of their statutory capacity are indispensable parties in structuring the asset-backed securities. One of the big things that I wanted to cover here under UCC versus local law jurisdiction, I wanted to save some things to discuss with you guys, but here on the instruments, the accommodation instrument, non-negotiable instrument, I do have very specific case law, controlling case law related to this instrument not being negotiable. Okay, so very, very important. Get with us on that. I'll make sure you have that case law to support that. Conversion of an instrument. Here's some important information and some sources that I would take a look at, and I'll make sure you have copies of these. I went through the Missouri Law Review, Robert E. Young, and started to look at commercial law conversion, liability of collecting bank to payee of negotiable instrument, and the defense of Uniform Commercial Code 3-419. This is where I really started to get a clear picture of accommodation transactions and understanding the mechanics of executing the instrument so that the tangible note, the actual debt itself, can be converted into digital form to strip the receivables. Okay, and so another source that I used was LexisNexis, the legal newsroom contracts and commercial law, statutory conversion of UCC 3-420 delivery required. I wanted to add this information. This is language from a California appeal court. The debtor/consumer was not an authorized agent to receive the checks on behalf of the factoring company. That's the accommodation party. The California Court of Appeal held that the factoring company, the special purpose vehicle, failure to satisfy the delivery condition of the UCC 3-402 A2 and invalidated its claim, reversing the trial court. So big thing is once the tangible note has been converted, it's not a negotiable instrument. It's not an enforceable instrument under local laws of jurisdiction and what was required by negotiation to enforce the lien. So the conversion of the instrument to electronic chattel paper excludes now the holder of the tangible debt's right to enforce the mortgage lien. Okay, so we're going to go through temporary perfection at the time of origination and how they lost perfection over the lien. We're going to cover that as well. Again, I'm going to make sure all these notes are available for you so you can have you can verify and vet all this information. Okay, so I think maybe I've done a decent job of hitting the critical points, but we'll go back over it. But here is what, in my opinion, what I deal with every day. These issues here. UCC 201-3308-7501. Okay, so let's clear our minds for a second and let's just focus on what it is that the bank's purporting took place, right? So they're purporting to be a holder of the debt, right? Well, we already confirmed by going through the MERS manual, right? MERS is making very specific language. We can't transfer debt. We only control the chattel paper. Negotiating the debt can only be done by proper endorsement, negotiation, acceptance, delivery, perfection of rights. In addition to the lien, that would require release and reconveyance between each holder to maintain clear and marketable title and secured interest over the lien, to maintain perfection over the lien. Negotiation means a transfer of possession, whether voluntary or involuntary, of an instrument by a person other than the issuer to a person who thereby becomes its holder, except for negotiation by a remitter. Okay? If an instrument is payable to an identified person, negotiation requires transfer of possession of the instrument and its endorsement by the holder. If an instrument is payable to bearer, it may be negotiated by transfer of possession alone. We all know 3205B. Okay? Well, let's get into holder in due course capacity, because that's essentially what this is saying. This is a true sale and perfection transfer of rights. Okay. So proof of signatures and status as holder in due course. Okay. And this is to get past the statute of frauds. The main thing that I want you to understand is that proof of signature and status of holder in due course can only be illustrated by form of negotiation and requirements of due negotiation under UCC 501. So we've all seen under negotiation of the instrument itself for full value. I covered this once before. So essentially what the state requires, let's talk about local laws of jurisdiction. We can talk about Texas. That's a pretty easy one. 192.007 is the state statutory requirement for local laws of jurisdiction to enforce the deed of trust lien encumbering the property. So essentially what the state's requiring is that you illustrate and prove in terms of proof of claim that you're the holder of the debt, the tangible instrument, and that you can illustrate that you've acquired it's incumbent upon a successor in interest statutorily in terms of proof of claim to illustrate how they came into possession of the instrument and whether or not they acquired that instrument statutorily with rights to enforce the debt. Moreover, rights to enforce the debt over the mortgage lien. Okay, so that can only be derived from proper negotiation and transfer of rights in the instrument, a true sale. Okay. And again, this is what the banks are typically coming to the courts with, is a copy of the note as it exists today with a no payee named as a bearer instrument, and they're citing that they physically negotiated the instrument, maintaining perfection over the lien in a bearer capacity, right? Well, we've already covered that could not have happened in an ordinary course of business, because an ordinary course of business would mean that the original lender executed a contract with the homeowner as if the homeowner was in the capacity of the beneficiary of the debt. Well, in order to be the beneficiary of the debt, you have to be the entitlement holder to the instrument, negotiating your promise as an entitlement holder. Again, we've covered in the exchange transaction, the order of operations. The homeowner's signature on the instrument and negotiation of the instrument is not step one. The bank accepting the instrument and depositing the instrument and giving consideration is not executing a contract. That didn't take place. Therefore, to create an order paper and call it a bearer instrument under 3205B with no payee named doesn't constitute negotiation in bearer form, okay, under 3205B. This is the biggest challenge that everybody's having in judicial and non-judicial litigation. They don't know how to discern how to challenge their proof of claim as being a holder of the debt. Oh, well, they're a holder of the note, so they caused an assignment of the security instrument for transfer of enforcement rights, so they must be the secured party of record. Nobody else, no other financial institutions challenging their secured party status. So you're still in possession of the collateral. What's the issue, right? How have you been harmed? That's the million-dollar question. Well, you're not going to be able to defend the collateral if you continue to make an admission that you negotiated your note in your promise to be the beneficiary of the debt. You're acquiescing into a transaction that did not take place at all. Okay? What you actually signed in, and I'm going to make sure and cover this here, a document is duly negotiated if it is negotiated in the manner stated in the subsection to a holder that purchases in good faith without notice of any defense against a claim, which is essentially a true sale, and for value, unless it is established that the negotiation is not in the regular course of business or financing involves receiving a document in settlement of payment on a monetary obligation. Well, what does that mean? Okay. Well, let's talk about what that means. Okay, so 3419 is the accommodation of the tangible instrument. This is the conversion or statutory conversion of the instrument. Okay, delivery required. Let me go back to, I gleaned the information I wanted to cover here. So this is where that particular article is where, one second. This particular article here is where we glean this information. Okay, so 3420, delivery required. The debtor customer was not an authorized agent to receive the checks on behalf of the factoring company. The California Courts of Appeal has held that the factoring company, right, must be able to illustrate that they were delivered the instrument in accordance with the statute, okay, or else their claim is invalidated. So for those of you that can prove that they never were delivered the tangible instrument, that's going to be an important statement of fact, obviously. But the stripping of the receivables through conversion and whether or not revised Article 9 applies to the lien on real property, we're getting to the root of the issue here, okay? So big thing that I wanted to make sure is that this is not we know now that the note wasn't negotiated in an ordinary course of business. We know now that the homeowner is not an account debtor, and step one is negotiation, acceptance, and consideration, a contract. That didn't happen. We understand order of operations now based on the SPV 1031 exchange chart. Okay, so what is the special purpose vehicle making a claim to? Well, they're essentially stating here under let's go to 9203G. Let's do that real fast. 9203, attachment and enforceability of security, interest, and proceeds, supporting obligations, formal requisites. So this is the common law rule that everybody gets beat with the tangible promissory note in bare form. Lien securing right to payment, the attachment of security interest in the right of payment or performance secured by the security instrument or lien or personal real property is also attached of a security interest in the security interest, mortgage, or lien. Okay, so essentially what they're claiming is a transfer of an obligation carries the beneficial interest evidenced by the lien and the lien itself to the successor. Okay, so that's how they're able to make the connection to maintaining a beneficial interest over the lien while negotiating the tangible instrument in bare form under a purported ordinary course of business. Okay, so this is the lie here, that they negotiated the note in an ordinary course of business and that the common law rule 9203G maintains perfection over the originally recorded lien. Therefore, they can make a bootstrap assignment of the deed of trust lien for rights of enforcement at any time, and that's where you're seeing the MERS assignment being executed years later after the closing date of the REMIC trust. Okay, so for you, those of you that are paying attention, that's what they're claiming. They're claiming we were negotiated the note. We don't have to maintain a chain of title. It was negotiated in bare form. Under 9203G, we maintain perfection over the originally recorded lien. Therefore, we're just bootstrapping our interest years later to enforce an in rem action against the real property, enforce an alternate means of collection. Okay? So they're claiming, just to reiterate here, they're claiming true negotiation. They're claiming that there was duly negotiated, okay, in a matter stated in the subscription as holder that purchases in good faith without notice of any defense for value, okay. What we're saying is no, you didn't, okay. What you actually did was an IRC 1031 exchange, right? Let's go back to that chart again, where step one, you induced certificate holders through special deposit, right? You sold cash flow purchases of ABS securities. So you sold the securities under the 1933-34 Exchange Act. You submitted your prospectus supplement and you dumped the securities to Wall Street. Okay. So now the securities are sold and they're in special deposit. Now you have the deposited funds to create the line of credit for the exchange, right? So here are your qualified intermediaries who send the warehouse line of credit down to the sponsor bank and originator at the closing table to table fund that obligation, in which the originator is the account debtor as accommodated party, and you are the guarantor, the homeowner is the guarantor on the obligation, and providing the real property collateral to secure the accommodated party status so that they can use your name and creditworthiness on the obligation as accommodation party and pledge the real property into the exchange to create the offering on the secondary market. That's just what happened, bottom line. It's all here for you to vet, okay? So again, that's covering step 2, the credit swaps, okay? And that goes backwards and forwards in terms of the asset coming back to the REMIC and securing before the cutoff date of the REMIC, maintaining perfection over the obligation as trust property, okay? Again, here is the supporting cases on the exchange for non-simultaneous exchanges on real property and the requirements of qualified intermediaries and the entity structuring for the tax pass-through structure, okay? So this stuff is understanding the entity structuring, the Tax Reform Act of 1986, the Starker case on order of operations and what's taking place, and the requirements of these parties in the entity structuring and their statutory capacity. So what's actually taking place, what are they actually negotiating, and what is the REMIC making a claim to, okay? Here is the scope of Article 9, and this is a very, very important. So how do we use equity to get equity, okay? You're the real property owner, step 1, right? So step 1, you've pledged the real property itself, okay? And you've encumbered that with a lien on real property governed under local laws of jurisdiction. Okay, and local laws of jurisdiction requires negotiation of the obligation so that you're a holder in due course on the obligation in order to enforce the deed of trust lien, to enforce the power of sale clause. Okay, so in order to, what that means in a nutshell is in order to maintain the beneficial interests and rights of enforcement, you have to illustrate that you're a holder in due course. That's essentially what the state requires under local law of jurisdiction. Okay. The reason why we wanted to take you here is to kind of close the loop on whether or not revised Article 9 under the like-kind exchange, okay, meaning that whether or not the lien will secure the electronic chattel paper as after required proceeds of the real property itself. Okay, I'm going to say that again. We want to know whether or not revised Article 9 specifically allows for the deed of trust lien to not only secure the tangible note, but also secure the underlying receivables that's bifurcated from the tangible note in the form of electronic chattel paper. And my contention is one lien cannot secure two obligations, okay, in terms of that. So, but to get even deeper, let's focus on the singular claim of the defaulted receivables, the electronic chattel paper. So under revised Article 9, they're saying, well, we were negotiated the receivables, so we have an equitable claim to the senior secured party in the exchange lien, the originating party, under 9203G. So under revised Article 9 and 9203G, they're causing an assignment to be recorded in their name under an equitable claim to the original lien in the exchange, right? Well, that revised Article 9 specifically only makes way for collateral in the form of personal property. So let's say, for instance, like an auto loan or a vehicle or a boat, that collateral is personal property. Revised Article 9 and the scope of Article 9 itself is very specific, that type of equitable claim to the real property collateral is not supported here, specifically on, here we go, D, inapplicability of Article 9. The creation or transfer of an interest in a lien on real property, including lease or rents thereunder, except, well, that's fine. But we're going to go here, liens on real property, okay? So it's very specific language, okay? That you may be able to hypothecate a secured interest in personal property, okay, at real collateral, but not in prime market real property collateral. The state requires that you be negotiated the debt in order to enforce the lien, okay, and the lien does not secure the debt and the subsequent receivables negotiated in the exchange, okay. So last but not least, we'll kind of cover the temporary perfection. I want to go over, next time I'm going to cover temporary perfection under the lien, and we're going to do a equitable estoppel declaratory judgment based on unconscionable contracts and revised Article 9. So we're actually going to do another one on an equitable estoppel declaratory judgment related to the like-kind exchange and how they knew or should have known, right, that this was an unconscionable contract and they were forcing the inventory lender to breach the deed of trust or mortgage lien based on their requirements to release the lien. Let me set the foundation for that real quick. So this is your standard security instrument. And the perfection of the lien under Article 9. So it takes free of the security interest created by the buyer or seller. Of course, the purchase is dependent on an ordinary course of business. Well, we've already discussed that. The security instrument. So under the deed of trust lien itself, let's see what we've got here, if I got one in front of me. What we're going to set up on the next webinar is going through equitable estoppel. And we're gonna stem it from this covenant here, reconveyance. Upon payment of all sums secured by this security instrument, lender shall request trustee to reconvey the property and shall surrender the security instrument, all notes evidencing debt secured by the security instrument to trustee. Okay? So, did they or did they not sell the tangible note? That's the question, right? So let's look at the controversy. Did they or did they not sell the note, the tangible debt? That's the question. They're claiming they did, right? So that requires the original beneficiary of the lien, which is in this instance, let's see. In this instance, they're purporting to be Countrywide Home Loans, Inc., right? And Countrywide Home Loans, Inc. has named here MERS, Mortgage Electronic Systems, right? The electronic software system they've deployed to control and hypothecate a secured interest in the electronic chattel paper here, the beneficiary of the lien. Electronic agent, they've identified them as the beneficiary under the security instrument, right? So what I want to do is show you at the end of the like-kind exchange and post-sale what that actually means related to, so again, here's the beneficiary of the lien, okay? And then we've got rules of severability, and then we've got the reconveyance and covenant, reconveyance and release clause. So, and I'm just talking about, now I know everybody's going to say, well, the receivables, they can sell an interest in the loan as well. That's our question. That's where we want to get. And I'll go back to receivables, but here's how we're going to start it. Okay, and here's the clear picture. Upon payment of all sums, upon selling the debt, okay, the beneficiary of the debt will release the lien, right, and reconvey the property, reconveyance. Okay, release and reconveyance. Well, this is what a reconveyance looks like. Strictly from right here. MERS is releasing and reconveying the deed of trust. Okay. So now that we've seen it, we know what release and reconveyance means, right? To maintain clear and marketable title. The question is, did you sell the tangible debt or not, right? Did you sell it in an ordinary course of business? Well, we know that they can't in the exchange, but now we want to focus on, well, what did you sell? Well, you bifurcated the electronic chattel paper in the exchange. Okay, I understand that. That doesn't require a release and reconveyance of the original lender, but the original lender maintains the right to enforce the lien while the lien's still perfected. Bottom line, they still maintained rights of enforcement of the contract based on local laws of jurisdiction and required negotiation to enforce the lien, to enforce the in rem foreclosure. Okay, so again, I wanted to give way to you guys here in the contract to an equitable estoppel declaratory judgment related to the exchange, which we're going to cover the last bit of Article 9 and how they lost perfection. Okay, but I wanted to change the narrative, if you will. Okay, change the narrative. I've seen, you know, we hear a lot of times, and we see from attorneys, we see from purported gurus, we see from a lot of different folks out there that they're still chasing down that debt. They're still walking into court saying, I negotiated, I issued a note. No, you didn't. No, you didn't. The financial institution that originated the loan issued the payment obligation. It was their note. You're the accommodation party. You signed as a guarantor to them, so they could sell to the special purpose vehicle a residual obligation, the after acquired proceeds or electronic chattel paper, that MERS is purportedly, right, securing, evidenced by the deed of trust lien over the collateral, which, based on revised Article 9, does not apply, okay, in terms of the scope of Article 9 under 9109.11da, okay? So this is no longer what I wanted to accomplish in this deal. Is, look, I'm not an attorney, I'm not a guru, I'm a sales manager. I've been in this industry from day one, so I've worked with all you best and brightest out there in terms of understanding this transaction. And what I want to do today is change the narrative of, this is not a negotiation and transfer of the debt. This is not a negotiation and transfer of enforcement rights over the contract. This is a like-kind exchange, which is a bifurcation of the receivables, the value of the contract, the asset to the special purpose vehicle, so that the certificate holders could acquire that personal property right to collect the payment stream evidenced by the tangible instruments, okay, in the exchange. So the obligation, okay, is not your obligation. The note is not your note, and it's not your loan. So your fight is not about whether you're in default or not on the obligation, okay? Your fight is whether or not the defaulted receivables that was negotiated to the REMIC in the exchange gives them an equitable claim to make a claim on the defaulted receivables to cause an assignment of the original inventory's lien under 9203G and revised Article 9. That's your question to the court. You've got to use equity to get equity. You got to stop making admissions to a contract as a beneficiary of the debt, okay? Because you're in possession of the collateral. You're in superior possession as it relates, in superior position to the original contract. Make no mistake about it. You're holding the real property. You're in possession of the collateral, okay? So you, in order to get equitable relief, have to use equity to defend the property and show that they have an unequitable claim in the exchange under revised Article 9 to the original lender's lien. Now, the next webinar we're going to do is to show how the original lender lost perfection over the lien and clearly illustrate equitable estoppel in the declaratory judgment, okay? So with that, you know, I do the best that I can to try to transfer the information to you guys. I wanted to give you a visual representation, step by step, of the exchange. All the supporting material facts here are available to you. Give us a call, shoot us an email. We are the nation's premier provider for Bloomberg securitization audit and expert witness affidavits and packages. We provide legal form preparation from all 50 states for real property disputes. The best way to reach us, 310-432-6304. Again, my name is Damian. I want to go ahead and take the opportunity to open it up for questions, if we have any questions at this time. Oh, we do. Okay, here we go. Yeah, I will definitely make a summation of that. Let's see, when can I get a PDF to your show? Cannot read anything, it's too small. Okay. What happens if depositor didn't enforce the note? Okay, Mark Freeman has a question here. What happens if the depositor didn't enforce the note? Well, again, the depositor is a qualified intermediary on the asset, Okay, so they're the last person to deposit the electronic chattel paper. They're never negotiated the notes with rights to enforce the debt. The note is not a negotiable instrument under Article 3. Okay, so the note is not a negotiable instrument to transfer by negotiation, acceptance, and perfection of interest to the depositor to enforce. Now, the depositor was the account debtor on the electronic chattel paper. So what a clear picture is that the Remick Trust, who was negotiated the receivables by the depositor, is actually coming after the wrong party on the obligation. The moment that they bifurcated the receivables and transferred the electronic chattel paper, they're accepting account debtor status or account debtor on the receivables. So what should have taken place is actually the Remick, the trustee of the Remick, making a claim on the payment obligation. Okay, to enforce the payment obligation related to the negotiated receivables. They're the last party to negotiate the asset before the asset becomes trust asset before the cutoff date, trust property, right? So again, the defaulted receivables, they should have went after the depositor on the payment obligation, okay? We're only the guarantor to the original inventory lender. Okay, so I hope that answers your question. The depositor was never in position to enforce the tangible note. Okay. What if you don't have MERS? You know, the DTC system and the PTC, Mr. Pearson, if you want to touch base with me, I can send you information on the DTC book entry system and the PTC book entry system, which is what the MERS vehicle essentially, they modeled those two book entry systems. So I'm assuming you may have a GSE loan or something like that. So I'll be able to help you with that. Just shoot me an email.
Hey you, my name is Little Tony, and I'm in the garbage business, as in taking out the garbage, if you catch my drift. Hey, it's not like I'm being subtle here. Now listen closely, cause I got a message for you. Turn on those ear holes. If you're currently experiencing a little difficulty with your mortgage, aka you're facing foreclosure, you got three basic options. Option 1, you could sit there like a potato and let them steal your happy little home. You gonna do that? I don't think so. You don't look like a potato to me. Option 2, you could sue the bank for mortgage fraud. Now, for option 2, you're gonna wanna call Fraud Stoppers because they can show you a proven way to save money, save the moolah, and increase your chances for success. And who doesn't like to succeed? Now, I do have another option that I don't usually bring up. You could hire me and the boys for a little shakedown action, or a mock funeral if you know what I'm talking about here, or a real funeral depending on how far you're willing to go on this issue. But I gotta warn you, option 3, it's gonna cost you 10 large, and it's a risky. I mean, I don't want to mention any names, but the last guy who picked option 3, he got pinched, and now he's doing a dime at Folsom. Not the best place to do a dime. AKA, he's singing the blues like Johnny Cash. And I don't know about you, but I don't like singing. So, do yourself and the family a favor and call the boys at Fraud Stoppers today. Because when the banks break the law, Fraud Stoppers, they break the banks. Now, get out of here. We're all done. I'll see you around.
I'm stuck in Folsom Prison, and time keeps dragging on. But that train keeps a rolling on down to San Antone. When I was just a baby, my mama told me, son, always be a good boy, don't ever play with guns. But I shot a man in Reno just to watch him die. When I hear that whistle blowing, I hang my head and cry.
Well, Thomas, looks like there's an attorney on there. Interesting argument, but let me read it the way that it's written here. This is a very interesting, but I can see a judge's eyes glazing over, and the question being asked: so how does this show that there is no standing to foreclose on the mortgage? Well, again, let's cover that one real fast. So what's actually being secured by the lien? greatly expands the definition of proceeds so that the security interest in specific collateral will be automatically extended to the electronic chattel paper after required property that is derived from the original collateral. That's what they construe. The electronic paper is after required collateral of the real property itself. Okay? So that being receivables and not negotiation of the tangible instrument, the debt itself, okay? Very specifically, this obscure equitable claim under revised Article 9 to the lien is not supported on liens on real property. It's supported by personal property collateral, but not real property collateral. So he can glaze over his eyes all he wants to, but as an appealable issue, it's pretty specific, okay? So I can't really speak to the judge's disposition or what his understanding of the argument would be, but we're definitely going to use equity to get equity and show that the lien lost perfection as a matter of enforcement rights.
I've had this problem.
Big problem.
I really needed
A good lawyer.
and I kept searching and searching.
There are so many choices.
It's really hard to find one that has all the things on my list.
But I finally did it.
Yes. Thank you.
If you are looking for one as well, look no further.
Here's a really good one.
Just use mine.
Use mine.
I'm very satisfied.
Definitely recommend. Problem gone.
Thank you.
Your position is one, the lien cannot secure two obligations. Why not? Legal basis of the position. Sure. Let's do that real fast. Actually, that's a really good question because that question is what drove me to understand this. So I had a lot of mentors, and I'm sure you guys that have been around for a while have seen this before, right? This was kind of a cursory statement that was given uniformly across the country and from a lot of different folks. So 3-203, this has to do with negotiation, transfer, and delivery under 7501, okay? So under 7501 and 3308, here is what we're looking at. Transfer of an instrument, rights acquired by transfer. So I hope you're following here, okay? Under subsection D, a transferor purports to transfer less than the entire instrument. Okay, so let's stop right there. Your position is one lien cannot secure two obligations. Okay, so a transfer of an entire instrument is not two obligations. It can only be one instrument. The tangible instrument over the death still perfected with the receivables, meaning the personal property interest, the personal property right to collect the payments on that contract have not been bifurcated to an investor. Okay, so essentially the note can only be negotiated with beneficial interest maintained over the lien if the instrument is negotiated in a true sale in an ordinary course of business. That used to drive me bonkers. Absolutely. It's actually probably what made me continue to be a hound dog and figure out what this meant. If a transfer reports to transfer less than the entire instrument, negotiation of the instrument does not occur. Okay? So ex facto, right, that the bifurcating and creating another obligation, the receivables, the beneficial interest in the lien cannot secure the tangible instrument if the lien has been, if the receivables has been bifurcated and negotiated to a third party. Who has rights to enforce the lien, the receivables or the holder of the tangible instrument, the inventory lender? That's the question of equity. That's what I meant by use equity to get equity, Mr. Thomas Nicotera, okay? I understand the judge, this is an issue of equity. Well, if we have two obligations, the tangible and the receivables, and only one lien, which one is it securing? The debt or the receivables? Who has a more equitable claim to the lien, the inventory lender or the REMIC? Or either, now that they've lost perfection, which we're going to cover next, okay? Let's see. How can I be a debtor when I am the creditor? Miss DeCurmier, you are not the creditor. Look up 3-419, UCC 34-19, subsection C. That is your capacity. You're a surety. You're a guarantor. You're a scapegoat. Okay? You're the last party. Your signature didn't create the debt. They issued the note. The inventory lender issued the note as an accommodated party. You accommodated them with your signature and allowed them to use your creditworthiness and name so they could receive a line of credit or a loan as an account debtor. So again, thank you for that question, Joyce, because that's what I'm trying to get people to understand. Their indoctrinated understanding of the contract is their signature represents step one. Negotiation of the tangible debt took a private physical daisy chain, so they didn't have to record a chain of title from either state to state to New York or Delaware as if that's the chain of title. That's an absolute fallacy. That didn't happen. None of it. It's a digital transaction that the MERS vehicle tracks. Okay, so you're not a debtor. You're surety into the exchange. What happens if they show the original note in court and the judge accepted it as true and said the defendant is obligated to pay? How do they get the original note? Well, let's talk about that in discovery. This is what I wanted to get to you with in terms of conversion, okay? And what they do in bearer form. So let's go back to conversion real quick because that's important. That's a good question. This is specific language from the California courts. The California Court of Appeal held that the factoring company, okay, failure to satisfy delivery condition of UCC. So when conversion of an instrument means that you're stripping the tangible debt, the tangible UCC note, which you have to sign it to get passed down. A promissory note, a tangible instrument, is executed to evidence an obligation exists, right? You're not going to leave that to electronic systems. I mean, they could have a hiccup one day, and all of the southern region of Florida may be an account debtor to an obligation, right? So in terms of that, that's not possible. To get past the statute of fraud, you have to sign the promissory note, okay, the instrument itself. Now, the underlying value, the electronic chattel paper, okay, or the obligation, the payment intangible obligation, okay, is stripped through conversion, okay? Just because you convert the instrument doesn't mean the piece of paper disintegrates and poof, it's still sitting there as a piece of paper, but you stripped the right to collect payments and sold that to a successor investor or REMIC trust by securitization, okay? So that's important to understand conversion here. In terms of why I wanted to show this to you, failure to satisfy the delivery condition on the instrument, okay, is an affirmative defense that I wanted to show you guys, okay, and just explain what conversion of the instrument is. If they convert the instrument and bifurcate the underlying value, that instrument is not enforceable over a lien on real property. Now, if they negotiated the note, right, to the REMIC trust in an ordinary course of business, they did everything right, the note got there, the debt got there, and then the REMIC created a subsequent transfer of the receivables to investors, then they could show up with a copy of the note and enforce that, but we know that didn't happen, okay? So Mr. Hernandez, get with me on conversion, and I'll make sure you understand the dynamics around conversions and the requirement of the holder of the receivables related to their claims, okay? We'll come back to that. Yeah, you know what, Mr. Hansen has a good point here on, you know, the Chapter 11 arena is one where, again, in terms of my learning process and proof of claim. So proof of claim, okay? This is very important, Mr. Hansen. Anybody that's looking at doing like a Chapter 3 adversarial complaint and leaving the real property unsecured, okay? This is what we're going to cover on the next one in terms of equitable estoppel, okay, and their obscure claim through revised Article 9 to the inventory lender's lien, okay. The REMIC must be identified by a properly evidence of perfection of security interest, okay. That's important for everybody to understand here, okay. Has an instrument number and is a piece of paper recorded against title. It's just a piece of paper with symbols on it. That's all it is. Okay? Whether or not that lien is still statutorily perfected, they maintain perfection over the lien, okay, is really the underlying element under proof of claim. Anybody could have a recorded lien against your property, but right, if I wanted to go record a lien in public record, I could commit a felony and record a lien and try to enforce it. Guess what's going to happen? You're going to sue me. You're going to move for discovery, have me identify business records of how I have substantiated the right to cause that assignment to be recorded. So I'm going to have to prove that we executed a contract, there's an obligation secured by lien that you pledged as collateral. You tracking? Okay, so same thing here. They may have an instrument via a MERS assignment, right? MERS is just a book entry system hypothecating a secured interest in the chattel paper, right? Purporting that the deed of trust lien is still securing that, which is BS. Okay, so we're going to show that. Evidence of perfection of a security interest. We're going to show that the original recorded instrument, the original lien, okay, all the challenge of standing, that assignment is void, they didn't have rights to cause the assignment, you missed the boat. You don't have privity of contract to the assignment, okay? So the real issue of void or voidable derives from whether or not the originally recorded lien lost perfection. And that's what we're going to prove. Based on the like-kind exchange, they did not or could not hypothecate a secured interest in the receivables, not on liens on real property. That's what we're going to prove. And then we're going to show how statutorily under Article 9 and equitable estoppel, they lost perfection over the lien and have no equitable claim to the real property, legal or equitable, based on the instruments. Okay? So we'll come back to that, Mr. Hansen, for sure. That's right, Mr. Kelly. You hit the nail on the head. That's why I wanted to really transfer this information to you guys in terms of, I see, you know, I'm not gonna give names and faces, but we see articles and people directing people to, you know, proper party to enforce the contract and all these things, and they're still tracking down negotiation and agent to principal relationship emerges, and then a non-payee named in a special deposit on the instrument or the holder with rights to enforce the note. I've seen every argument there is to understand on the negotiation of the obligation, and I wanted to create this absolute diversion into the proper understanding of what they're claiming. They're not claiming to be a holder of the debt. They're claiming to be the holder of receivables. And as the holder of receivables under revised Article 9, they have an equitable claim to the originally recorded lien, which they've assigned through MERS and public record. That's exactly what's going on. So you, the equity holder of real property, this is what James is talking about. You are the whole owner unequivocally of the real property equity. Okay, so right now the only thing between you and the third party who's making an equitable claim through the defaulted receivables is that lien. You see the two issues of equity? You're the real property owner defending the equity from the lien. The third party's claiming they were negotiated the debt with rights to enforce the lien, or the receivables and a right to cause an assignment and enforce the lien through common law rule of a transfer and obligation carries the lien and the lien itself. Moreover, under revised Article 9, hypothecating a secured interest in the receivables, the electronic chattel paper, by the originally recorded lien. Well, we know that that's not possible now. Now we know what really happened. Now we know we're not the account debtor. That's not my note. That's not my loan. And what is actually happening here? They're making we got to use equity. We've got to defend the property by showing the REMIC has an unequitable claim under revised Article 9 to the deed of trust mortgage lien. And then we got to show, which we're going to cover on the next one, exactly how they lost perfection statutorily over the lien based on what they claimed. Okay? On to the next question here. I already have a loan signed, modifier, Nation Star. Can we still sue based on this platform? Are we doomed? As long as, in terms of if you've accepted a modification, okay, hold on one second. If you've accepted a modification, and in the modification agreement you've acquiesced to no future litigation, okay, that could be a challenge if you wanted to bring an issue for damages or equitable relief. Okay, so read your contract. If you have any questions, you can forward that to us, and we'll go through it and review that with you related to that. But as long as they're illustrating that the beneficial interest of the original recorded lien is still securing the modified receivables, we're fine. We're fine. Where do I find the release and reconveyance? It's usually always going to be covenant 19. It's going to be like 19, 20, 21, 22, 23. It's usually right there at the back end of that. Okay. Okay. So a lot of the same questions. Okay. But again, let's just hit the nail on the head. Who's the last person to release the lien? MERS. Who's the only person that can release the lien? MERS. Who can't negotiate the debt? MERS. Who controls the electronic chattel paper? MERS. Who's hypothecating a security interest in the electronic chattel paper? MERS. Okay? So, and again, those of you that don't have MERS and they're using a different book entry system, we can help you with that as well. Okay? I just wanted to give you a clear picture. Here's the reality of it, y'all. These Wall Street investment vehicles are no different than if you and I were real estate investors and we created a private REIT. And we bought real property and we transferred that real property to the trust, and we created a private placement memorandum where we sold securities and bifurcated the right to collect payment through those securities on the real property. Well, guess what? All we did was sell the right to collect payments on those 30-year instruments. We didn't sell the real property, and we didn't transfer rights of enforcement of the liens itself. Okay? That would be absurd. That would be nonsensical. Okay? It's the same transaction, but just on a much bigger scale. This is a buy and hold model. They still control the collateral through the lien itself, okay, through the exchange. So the last party to release the lien is MERS, their electronic system that maintains the lien and the electronic chattel paper, or purportedly maintains the lien and the electronic chattel paper. So we're going to get back to them on the next one on equitable estoppel. I want to thank everybody for participating. We had a great turnout. Again, our office will be available for any additional questions. The expert witness packages, full Bloomberg securitization audit, full quiet title package. We do have the wrongful foreclosure package as well.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes. home.
You're the man! I've been looking for this for weeks.
Hi, I'm Jason. If you're facing foreclosure and you want to fight to save your house, but you cannot afford a lawyer, then I've got some good news for you. Now you can do it yourself and save thousands of dollars in legal fees. And it's not as hard as you might think. In fact, it's really quite easy. You may find yourself in a situation with Countrywide, Bank of America, Chase, Nation Star, Wells Fargo, HSBC, or maybe one of these companies. If so, there is a good chance your loan contains error, legal violations, breaches of contract, and fraud. Now, I'm sure you're looking for the most affordable and effective options available, correct? No worries, we've got you covered. With our easy non-credit-based financing and affordable payment options, you can fight foreclosure without breaking your bank. Getting started is easier than inviting Esther to the company Christmas party. Just go to www.fraudstoppers.org and click the Get Started Now button right here. Then just fill out this form, click the Submit button, and one of our agents will contact you right away to conduct a free, confidential fraud analysis to help you determine what your best option to saving your piece of the American dream is. It's as easy as that. Then stick around and watch some of our other videos. I'm sure you will see something interesting. Until then, thanks for watching and have a great day.
Hi, I'm Mary.
And I'm Jennifer.
Are you looking to save your house from foreclosure using the help of an affordable and competent attorney? Or are you thinking about doing it yourself? Pro se, so you can save money in legal fees? Or maybe you want a combination of the two, so you can save money and get the help you need. So get started right now and register for your free consultation. Get the help you need to save your piece of the American dream. Until then, take care. Bye.
When I come back, y'all better
Yo, Pop Boy, look, you got more food over here. Come on, homie.
Alright, you tough, right? We're gonna see what's up. I'm gonna be right back.
However you want to get it poppin', my block.
G.A.D. all day. Whoa, what's up,
Gangsta all day, homie. Poppin'.
You ain't wax your brother, man?
Yeah.
Yo, come here, man. Let me holler at y'all for y'all do something all y'all regret, man. First of all, that's not gangster, man. Y'all know who's really a gangster? Brian Moynihan's gangster.
Who?
Jamie Dimon's gangster. Yeah, who? Exactly. Y'all don't even know. Brian Moynihan is the CEO of Bank of America and Jamie Dimon is the CEO of Chase. They putting families out their home. And this house right here is in foreclosure. Whose house is this?
My house.
This is your house? Your moms know y'all in foreclosure?
Nah.
I bet she don't, man. What y'all beefing about anyway, man?
Kids.
Who cares?
Kids. I don't know, but it's whatever. That's
Nah. See, you shoot him, he shoots you, you kill him. Banks own these prisons, man, and they get paid from that. So you just putting money in their pocket, man. So y'all need to dead that. Y'all can come to our meeting every Tuesday. You know what I mean? Y'all come there. I show y'all how to organize this anger y'all got with the right enemy, Bank versus America. Y'all ready to fight these banks?
Yeah, man, I guess so, man.
That's what it is, man. Let me go in here and talk to your mother, try to help y'all save this house.
Hey, yo, good looking out, bro.
No doubt, man.
It's time to wake up and get with the movement. Hear the message in the music now. We can fight back or we can lay down, or beat back the bank attack and stay proud. They got bailed out, we getting sold out. Some living underwater in their own house. They hear the word foreclosure, they get scared and think it's all over. But nah, the fight just begun. It ain't gonna be easy, but it must be won. Cause Bank of America's bad for America. Congress held hostage, they kidnapped the treasurer. This ain't the dream in the land of America, but we could change that if we stand up together. Demand something better than the status quo. We elect, they neglect, then they have to go. We gon' beat back the bank attack. We gon' beat back that bank attack. We gon' beat back the bank attack. We gon' beat back that bank attack. Set up with the people, yeah, yeah, and down with the bank. Those green banks. Set up with the people, yeah, yeah, and down with the bank. Those dirty banks. Yeah, it's capitalism, political arcade. Stop the evictions, we picket and blockade. March and rally for social justice. Forge signatures, got the robo busted. Do the right thing now, reduce the principle. Job growth, increase residuals. We're solidified, can't divide and conquer. When we fight, we win. The pride to prosper. With people power, we equal the power. Civil disobedience to veto the dollar. Close our bank accounts, oppose their policy. Loan mod programs don't work, it's a lottery. So what do we do when the banks attack? Stand up, fight back. Yeah, and we don't want no cash for keys. We want to enter this catastrophe rapidly. We gon' beat back the bank attack. We gon' beat back that bank attack. We gon' beat back the bank attack. We gon' beat back that bank attack. Set up with the people, yeah, yeah, and down with the bank. Those greedy banks. Set up with the people, yeah, yeah, and down with the bank. Those dirty banks. Fannie Mae, you can't hide. We can see your greedy side. It's pain for the many, profits for the few. Wells Fargo, we're coming for you. Get your voice back, tell your story. Yell out, this is city life territory. We got the right to the city. Vida Urbana, life in the city. The rich get richer, the poor get poorer. Stimulus pack, first class Bora Bora. Meanwhile, we staring in the eye of the storm. Earthquakes, hurricanes, trying to hold on. But U.S. Bank, we're here to prove what? We shall not be moved. Only a judge can evict you. You wanna fight for your home? Yeah. Then we'll fight with you. We gon' beat back the bank attack. We gon' beat back that bank attack. We gon' beat back the bank attack. We gon' beat back that bank attack. Set up with the people, yeah, yeah, and down with the bank. Those dirty banks. Set up with the people, yeah, yeah, and down with the bank. Those greedy banks. The bank, yeah. Those dirty banks. The bank, yeah. Those greedy banks. The bank, yeah. Those greedy banks. The bank, yeah. Those dirty banks.